call this meeting to order. Thank you for coming. Welcome, everyone. Especially, I want to say happy Cinco de Mayo. I know you had a lot of places you could have been this evening, but you chose to be with us. And for that, I do thank you. So we do want to call this meeting to order. Do we have a quorum?
We do have a quorum.
Has everyone had an opportunity to review the minutes?
Two sets of minutes, Judge Milton.
Yes.
For approval of vote.
Thank you. I want to start with the minutes from December 1st, the minutes from the public comment hearing. Do you have a motion to approve the minutes from the public comments hearing?
I'll make a motion.
Thank you. Is there a second? All those in favor? Any opposed? Thank you. The minutes from December approved. Is there a motion to approve the minutes from December 2nd business meeting?
So moved.
Is there a second? Thank you. All those in favor?
Aye.
Right, those are approved. Next, we will move into the guidelines subcommittee reports. Who wants to say one?
Well, we have a couple matters for action items, some of which are repeat. Coming back after we got them back, but I'll defer to David.
Thank you, Judge Dean. I appreciate that. Yes, the guidelines subcommittee met on April 17th, 2026, and considered 3 issues, which we will present for you today. I am going to ask Stacy DeJaca, our staff research director, to present the first issue. So I'll turn it over to Stacy.
Sure. So the corresponding meeting memo for this agenda item is titled Proposed Removal of Select Sentencing Guidelines Worksheet Fields. You may recall that at its December 2nd, 2025 meeting, the Commission considered a recommendation from the Guidelines Subcommittee to remove select fields from the Sentencing Guidelines Worksheet, the majority of which are victim-related. While there was general agreement that the identified fields lacked direct utility to the guidelines, several commissioners expressed concern over removing the items before receiving input from victims' advocacy groups. As such, the Commission voted unanimously to send the issue back to the subcommittee for further review after receiving feedback from victims' advocates. Following the December meeting, Commission staff reached out to our victims' advocacy representative, Alethea Miller, to request her input and that of her colleagues. Ms. Miller, in turn, communicated with colleagues in Cecil and Hartford counties and the Maryland Crime Victims Resource Center. We very much appreciate Alethea's willingness to do so. The feedback gathered indicates that the victim information collected on the worksheet is not currently being utilized by victims advocates. However, they would like to see at least some of the victim-related questions remain to show victim participation and awareness. Further, they are agreeable to reducing the number of questions. At its April 16th, 2026 meeting, the subcommittee once again considered the removal of select worksheet fields, taking into account the input received from victims advocates. Consistent with that input, the subcommittee unanimously agreed to recommend to the full commission the proposed changes that are summarized in the table on page 5 of the memo. These changes would streamline but not eliminate the victim-related fields by limiting them to the following. Was there a victim? Was the victim present at sentencing? Was there a written or an oral victim impact statement? And did the sentencing judge order the defendant to have no contact with the victim? The proposed changes would also remove the fields subsequent offender proven and 50% of sentence denounced for crimes of violence. The corresponding proposed revisions to the guidelines manual and COMAR are located on pages 6 to 8 of the memo. That concludes my summary. I'm happy to address any questions. Otherwise, I'll turn it over to the commission.
Thank you, Stacy.
So we did talk about this in the subcommittee. I think we were all in agreement that helpful input. And I think it accomplished both sort of streamlining the forms, which hopefully makes it a little easier for those that are filling them out, but still captures that victim information. So I think we were all in agreement.
All right. The subcommittee is recommending that the commission do the following. One, remove victim court costs imposed, victim participation, victim notification form, victim notified plea, victim notified date, and no contact requested. Second, retaining victim, victim present and no contact order. And third category, combining written, is that victim impact statement and oral victim impact statement under the new field, victim impact statement. The subcommittee also recommends moving the fields subsequent, offender proven, and 50% of sentence announced for crimes of violence. These proposed changes are summarized in the table on the following page, which we just reviewed. Does anyone, well, is there a second? A recommendation?
Second.
All those in favor? Any opposed? Motion carries.
Thank you. For the second item from the guidelines subcommittee, I'm going to turn that over to lead the discussion to our staff, graduate research assistant and policy analyst, Julia Castero. Julia, can you give us an introduction?
The corresponding meeting memo for this item is titled Proposed Revisions for Scoring Physical Injury and Reorganizing Victim Injury. At its September 9th, 2025 meeting, the Maryland State Commission on Criminal Sentencing Policy adopted new language defining psychological victim injury for the purposes of scoring Part C of the offense score and assigned the task of next reviewing the definition of physical injury to the Guidelines Subcommittee. At its November 21st meeting, the Guidelines Subcommittee reviewed staff's proposal to expand the definition of physical injury in scoring Part C of the offense score. After discussion, the subcommittee asked staff to prepare a revised document with the proposed revisions before voting. Staff circulated the revisions following the November 21st meeting, and while the subcommittee generally agreed on the proposed language, they asked staff to reorganize the section to present the instructions in a more consistent and logical order before presenting a final recommendation to the commission. The proposed reorganization and revisions to the Maryland Sentencing Guidelines Manual are on page 2 of the memo. In addition to reorganizing the victim injury section, the staff also made some changes to the physical injury language. The current instructions for victim injury are found after the revised language in the gray bracketed text. Considering the subcommittee's discussions on revisions to both psychological and physical injury, staff reorganized the instructions for scoring victim injury into 3 main sections. The first 2 provide general instructions and proof requirements for both physical and psychological injury. And the third section provides specific examples of minor, non-permanent, and permanent injuries. The revisions to COMAR and the Sentencing Guidelines Worksheet will also be revised in accordance with any revisions to the language in the manual. And to note, the footnotes in this section are for clarification purposes only and would not be added to the manual or COMAR. Lastly, the revisions to table 6.1 of the manual are on page 4. That concludes my summary, and I will turn it over to the commission.
Thank you, Julie. Appreciate it. I think Julie did a good job summarizing. This has been a multi-meeting discussion that the subcommittee had. I think this was built off of the revisions this commission made with respect to psychological injury. After doing those revisions, we said, can further clarification be brought to the instructions for physical injury? Because prior they were really quite minimal, which is the word actually said, more than minimal was really the sole descriptor. And the staff also asked for examples of specific types of injury. We thought that was important because those are the questions the staff receives. And then Judge Shaw, I think, also made a really good suggestion just to generally reorganize the section because it had become a little hodgepodge with all the revisions. So I think we've accomplished those goals, and so that's how we wound up with the recommendations that we put forward today.
It's been recommended to we adopt the proposed revisions and the reorganization of the instructions that were reviewed by the subcommittee. All those in favor? Oh, well, is there any further discussion?
I have one question. Hi, everyone. This is Delegate Bartlett.
Good evening.
My question is regarding page 5 of the memo. Under Comar and number 3, victim injury, and then it's bracketed, this language will be revised in accordance with the revisions of the language. Okay, so I want to just make sure that the language that's going to go there instead will be the language that states that's on page 3 above, where it says 3 types of injuries and examples. Just want to make sure I understood.
Yes, I know that might be a little unusual. It will mirror the language that you see proposed in bold underlined language. That's the new language. It will mirror that.
Okay,
Comar formatting can be tricky and unique at times. And so instead of worrying about which we'll have to work with Division of State Documents on how that comes out, we said we'll mirror what this language is. It may just be formatted slightly different to correspond with how they like the language to appear in Comar, but the substance and language will be the same.
okay,
It might have different subsections or, the way they like to see it
gotcha.
presented in Comar.
Yep, okay, thank you.
Thank you. Is there any further discussion?
Make one quick comment and just say I really appreciate all the work done on this. We've come a long way through many meetings. Everyone's input, I really think it's well done. I think it's going to be helpful in practice.
Specifically the examples.
Yeah.
There's a lot of back and forth on this, a lot of hard work. Product really gonna be beneficial.
What was in there was very, yeah, it was very well done. Thank you, both people that helped us.
It's absolutely very clear and concise. So it's been properly moved. Is there a second? All those in favor? Any opposed? Next.
Hey. Oh, turn it over to my thumb on this one, huh?
Did I say motion carries? I'm
I
sorry.
think so. I think you said it was done.
Thank you.
All right. The final issue on the guidelines subcommittee agenda applies to the instructions for sex offender registration and how that applies to the offender score. And I'm going to present this particular issue. There is a corresponding meeting memo, which you all should have received. It is titled Instructions for Sex Offender Registration as it applies to the offender score. So I think as most of you know, but I'll just recap, the offender score measures an individual's prior criminal history for the sentencing guidelines, and it's made up of 4 components. Part A is the relationship to the criminal justice system when the instant offense occurred. Part B is juvenile delinquency. Part C is the prior adult criminal record. And Part D is prior adult parole or probation violations. This memo proposes to add to the sentencing guidelines manual and Comar language in Part A, instructing users that an individual is not involved with the criminal justice system for the purposes of calculating the offender score if the individual's only involvement was to comply with the ongoing reporting requirements associated with sex offender registration in the state or elsewhere. In terms of scope, this language would apply only where a defender is on the sex offender registration, but not on probation or parole and commits a new offense. A defendant who is on probation or parole when they commit a new offense will receive a point for involvement in the criminal justice system at the time of the instant offense and will be precluded from the criminal record decay factor, regardless of whether they were on the sex offender registration at the time of the offense. The language that we presented to you today is consistent with the rule that was adopted by this commission in 2019 and instruction staff have been providing to practitioners since that time. The guidelines subcommittee discussed this issue at its April 17th, 2026 meeting and decided to present the language to the commission without a specific recommendation so that all commission members would have the opportunity to voice their opinions. As some of you may recall, this issue was first brought to the commission's attention after Commissioner Fincy received a question from a criminal defense attorney asking whether sex offender registration would preclude application of the criminal record decay factor to the defendant's prior record score, which is part C of that component that I mentioned earlier. The subcommittee discussed that issue in 2016, but tabled it to see if we would get other questions from practitioners, and we did. So the staff brought that issue back and asked the subcommittee to again revisit that issue in 2019. At that time, the subcommittee voted to make two recommendations to the full commission. First, the subcommittee agreed that sex offender registration should not count towards the offender score for purposes of the decay factor, which reduces the prior criminal record by one level if the defendant has lived in the community crime-free for 10 years preceding the instant offense. The second recommendation from the subcommittee, which was a 3-1 vote, they recommended that sex offender registration should count as criminal justice involvement for the purposes of Part A of the offender score, which is the defendant's relationship to the criminal justice system at the time of the offense. The subcommittee also proposed corresponding instructions for the manual and COMAR that were consistent with that recommendation. The full commission, however, voted 5-7 against the subcommittee's recommendation to define sex offender registration as criminal justice system involvement for purposes of Part A of the offender score. Since the commission's vote with respect to Part A was consistent with its recommendation regarding the decay factor, the commission didn't formally vote on whether sex offender registration counts as criminal justice involvement for the purposes of the decay factor. There was no further discussion about instructions, and no instructions were added to the guidelines manual or COMA. Sentencing Commission staff continue to receive questions about sex offender registration since that time. And consistent with the Commission's 2019 vote, the staff instruct practitioners that that should not score or not count criminal justice system involvement for the purposes of the offender score. It should not score sex offender registration. Additionally, our training and administrative coordinator, Catherine, also knows these instructions when she's providing trainings to prosecutors, parole and probation agents, defense attorneys, and all others around the state. Given the frequency of the questions from practitioners, staff think it would be useful to include explicit language in the guidelines manual and COMAR. Pages 5-8 of the memorandum provide the proposed language, which instructs that sex offender registration should not be scored as criminal justice involvement for the purposes of the offender score. The memo also summarizes, per the request of the subcommittee, the history of the sex offender registration in Maryland, provides relevant case law that was discussed by this commission back in 2019, and we added this time treatment and other sentencing guidelines jurisdictions. No other jurisdiction that measures involvement in the criminal justice system at the time of the incident event provides explicit instructions as to how to measure or how to apply this to someone who is on the sex offender registry. So that additional research about other states doesn't really help inform our discussion much further. So this kind of comes to you as an open-ended issue. The staff asked for instructions to clarify this issue based on the 2019 discussion. The subcommittee had discussions about that recommended language and wasn't able to come forward with a full recommendation, but we're presenting it now today for further discussion.
Point of clarification.
Sure.
You said no other states
No other states.
explicitly, because we know that the federal US sentencing guidelines do not include sex offender registration as criminal justice system
They
involvement.
don't have formal instructions in their guidelines. It's similar to us. We did ask their educational staff that question in 2019, which you might remember. So I did report from their
Right.
their training staff that that's the instructions they provide, but it's not explicitly covered in the guidelines manual.
I mean, they have a definition of when you are involved. If you want to use the word involved. that
Right.
means probation, parole, a supervised release, imprisonment, work release, escape status, or revocation. And that's 4A1.1E, the United States Sentencing Guidelines. So obviously it explicitly defines what is, but doesn't say.
Yeah, they just don't mention, right, okay,
Just to be
I think
clear.
we're saying, yeah.
It's important, it's, you know.
Yeah. They don't say, right, so they don't talk about sex offender registration, but it's not listed among those that's included, so thereby you can conclude that it's not.
And I am called, I was curious.
Okay.
We called the training, not the training, but the helpline. The
Oh.
Sentencing Commission.
Federal sentencing.
Federal, United States Sentencing Commission, and the helpline person said it's never counted, but couldn't cite anything further other than that provision.
That's helpful.
I mean, I'm one of the people who's been here for a long time now, and I remember the discussion that we had before. And I think one of the issues was that, correct me if I'm wrong, because I'm not a lawyer, but you can be put on the sex offender registry for a really long time, even life, right, in Maryland? So the idea was, well, if you could, there's nothing you could do to get off of that, then how can that count as criminal justice involvement? You could be crime free for 25 years, you'd still be on the registry. And I think that was part of the commission debate in 2019 about why we thought that this shouldn't count as current criminal justice involvement.
Yeah, and I was part of that discussion. Rick was as well. So the subcommittee there, and I think ultimately where it sort of fell, where the two debates were back in 2019, was as to the decay factor, that very point, I felt like we all were in agreement that for purposes of decay, if someone's gone 20 years, they should get the benefit of not having reoffended for that. So I don't think that was a debate. As to the other, I think the question was back to that original core, which is, are the guidelines reflective of what judges do, or are we telling them? And I think the sense was for many, the other side was that judges would consider that in deciding like, if someone was on registration. That's one issue, that would be a factor that would be considered, how much would depend on the case. And the second thing is, if you look at the case law that described essentially, it is the equivalent of probation. In fact, I think the site, it was on page 4 when you noted the case law. It says it has a highly similar effect on petitioner's life as being on probation. That it was essentially intensive supervision. Sometimes you're having to go very regularly, check in, be monitored. So you're committing a criminal offense while already having a level of supervision that the next person doesn't have. So we're also trying to treat people similarly situated. So if one person is regularly on sex offender registration, being supervised and commits an offense, should that person be at the same spot that a person who doesn't have any of that and commits an offense? So that's really, I think, where the debate was. Is that fairly assessed where you?
I think there was also a lot of discussion of the nature of sex offender registration versus the nature of probation. And that a probationer is under direct supervision of a probation officer as to where they live, where they work, what they do, whether they have any contacts with the police, whether, I could keep listing all the requirements of probation.
Most of them are sex offender registration.
Not really.
Be a listed.
A sex offender registered person, excuse me, who violates any of the rules of the sex offender registry is subject to being charged with a new crime, requiring proof beyond a reasonable doubt to a judge or a jury. Probationer, on the other hand, is under this direct supervision, has backup time from the original case, and it's what preponderance of the evidence standard that the judge applies. There's no right to a jury trial. There's no suppression of evidence. There's no legal rights attached to it, and it is I think seen as a continuation of the crime that you were sentenced for. Whereas sex offender registration is a preventative, future thing that has been developed over the years, that is a consequence, lifetime offender supervision. I'm not saying it's common, because it's not necessarily common, but it's applicable to more to more offenses than even originally when, you know, and then there's 25 years and 15 years. So there are 3 categories. So it's very different than, I think, probation. And we had that discussion as well as part of it. Anyway, that's where it came down years ago.
Right, and it just became a debate as to what is meant by that being on supervision.
Can I just ask a back question there? If we're kind of in some ways mirror actual practice, that was a person on a sex offender registry commits an offense that is not a sex offense. Are they typically penalized for having been on the for being on the registry?
Hard to give a one size fits all.
Yeah, sure.
I mean, it certainly is raised by the prosecution, I would suspect, typically, these cases that I've had where it's going to get argued that they committed this involving offense, but a lot of it's going to depend on the nature of the offense. So if it was a driving suspended, probably not, you know, maybe other type of offenses, but if it was another person type crime, then that actually may, you know, like, well, we put you out, we had these safeguards and you did something else again, that obviously would be something that would probably be.
You're not referring to sort of the supervision of violent sexual offenders.
Well, we're
That
talking
was
about
your-
any,
And you're talking about any registry.
we're talking about any registration, so you obviously have different levels of registration. And I would say probably your lifetime registration is not as probably relevant on this issue because most of the time they have a different level of supervision overall. But your 15 years, 25 years, probably where this comes up more often, I think, when I say it, more than the lifetime registrations.
But I can see Mr. Fincy jumping up and down if someone is charged with a robbery and they're on the sex offender registry and that's being used against them. I mean,
That a sense.
yeah.
Well, ultimately, it's always up to the judge. I mean, whether it's counted as a point or not counted as a point, I mean, it's still a fact that will come up.
I mean, I'm not suggesting it's not necessarily a legitimate factor for a judge to consider.
Sure.
That's a separate matter entirely. I mean, that's up to the judge and his discretion. We're talking about assessing a point for something that has never been assessed before, and therefore that person's guidelines, which the judge takes very seriously, as you know, in assessing the sentence, is going to be that much higher. And keep in mind that that person already has, if he's on the sex offender registry, already has at least one very serious prior.
I reviewed the minutes, and when I reviewed the minutes, it seemed like there was a point of contention. Judges Avery and Judge Lewis did argue or discuss whether or not it would interfere with or how it would be weighed by judges. Judge Avery asserted that the registration status should be something to be considered, and that a judge should have the ability to use their discretion. Judge Lewis questioned whether it would be appropriate to apply 1 point for the entire term of a defendant's sex offender registration when the individual successfully completed his or her term of supervision. I just put that out there to say both sides of the argument.
If I could speak just to that point, just being on the probation side. Again, I do not know the legalities of things behind that, but what I have seen in a lot of instances, specifically when I'm doing worksheets and guidelines, is that if we don't consider the point, if they don't get the point, essentially it minimizes the score. And a lot of times, these offenders are reoffending outside of that window. Most of the time, from my experience, registered offenders more so do not have extensive criminal history, so they're not assessing a lot of points from the get-go. And so what I have seen, or we have a lot of instances in which these are cases that are sexual in nature or sexually violent, and then they get pled down. And so we're points or factors should be considered in their history, they're not being considered because things have been pled down or minimized. So I feel like giving them that point for the fact that they are on the registry, because a lot of times, again, we have certain persons who have been found guilty of assault seconds from the 80s up till recently, and they just got to a position. Now, all of those offenses or incidents have argued or have inferred that they were sexual in nature, or there were other, outside circumstances. But here we are, you have a person who has, 2, 3 assaults in their history, all of which are probably sexual in nature. And now we're in a situation, so they don't have any registry history. Or you may have someone that does have registry history and again, have been convicted of offenses that have been pled down or minimized or over what have you. So I think that it is important to consider their registry status when conducting the worksheets and guidelines, because those points matter. I feel like, especially when it comes to sentencing and those matters. That's just my experience on what I have seen from different defendants that I've, come in contact with.
Well, I cannot support the proposed change. It seems to me the issue is whether or not convicted sex offender is under criminal justice supervision. And the answer is clearly they are. If they're on the registry, they're being sued. They have to register. This is not my language. This is the language of the statute. They have to register with the supervising authority. That would suggest that they're under some kind of supervision. The supervising authority can be local law enforcement, parole and probation, or one of several other agencies that are in a position to monitor individuals in the community or in an institution. And it's not just they phone in, this is where I live. They have to report, depending upon the level of what tier they're on. They either have to report every 6 months in person to their supervising authority. They have to notify the supervising authority for a change of address, change of employment, change of school. And most importantly, in terms of supervision, at least in my county, the supervising authority, who is our sheriff's office, they go out and check. They just don't take their word on it. They go, if they say they're living at 2815 Colfax Drive, they go to 2815 Colfax Drive to see that they're really living there, to see, and they talk to the neighbors. They make sure that they're not living within a certain distance of the school. And when you get to the tier 3, which is lifetime registration, the supervising authority has the ability to order GPS monitoring, restriction on where a person can live for work. They can require treatment. They can require that the individual submit to regular polygraphs. All of that is clearly criminal justice supervision. So, if we don't like the sex offender registry law, which when I was in private practice, I didn't like it. It's draconian in some instances, but that's the law. And if the law says that they have to register for this period of time, then clearly they're under criminal justice supervision. And for us to say that they're not, I think is really not looking at the true picture of what's going on. And it does happen. We just in Calvert County, we had a fellow who committed a sex offense, rape, 20 years ago. And he was on the register. He was on the registration. He did it again.
I think you all, we're discussing two things. This committee already opposed. The committee has already opposed finding or deciding that someone who's on the sex offender registry has criminal involvement. The only thing I understand that you all are deciding today is whether or not you adopted the language. You are not revisiting whether or not somebody who is on the registry is criminally involved. That issue has already been decided. That's not what we're doing. The only thing you're deciding today is whether or not to adopt the language. As far as I'm concerned, you all voted on that in 2019. That's what the minutes say. That has been decided. The only thing that's before the committee today is whether or not you all are adopting the language that has been suggested and that we were discussed in the committee. Am I missing something? We are not discussing whether or not the committee is deciding or revisiting whether or not someone who is on the sex offender registry is criminally involved. Because when I read the minutes, the committee voted against that. Am I mistaken?
No, I think in the subcommittee, I think that's what happened. I think it was voted.
No. I don't think that's not what my understanding was, because in the subcommittee, the only thing that was proposed was whether or not we were adopting.
I didn't
the
finish what I
language.
was saying. I was saying in the subcommittee this time, the reason is back then they voted against the actual recommendation that was made out of the subcommittee, but no language was ever adopted in its place. So this time, because of the fact that it had never been adopted, that's why it was just sent through. There wasn't a vote either way this time on the subcommittee. Because of the fact of given that the way it went and it was so split, that it really required approval of the commission to decide whether this commission wanted to approve of that language. So I agree, it doesn't actually revisit the underlying vote.
Mhm.
That would be up to the committee if the commission decide if they wanted to send it back. But otherwise, it would either be to approve this language or to not approve this language. And if not approving the language, what the commission wanted to do after that. That's the way I saw it coming through. I agree, it's not a vote on whether or not we do something different today.
Okay,
It's whether that the language is approved, and if it's not approved, what do we do, if anything? And I think that was where some were just expressing
Right,
why
okay.
they didn't want to approve that language.
okay, all right, so I wanted to be clear that, but that we need to address the language first.
Right.
Okay. So where are we on the language?
I preface my remarks by saying I can't approve the language.
Okay, so you can't approve
That's
the
what I
language.
said.
Does anybody else have an opinion on the language?
Not an opinion on the language per se, but just a clarifying question, if I may. As I understand, the intention of this language is to very narrowly define when registry, or when presence on the registry does not count towards criminality for the purpose of computing score. What I'm not 100% clear on, and perhaps in a separate section of the manual, is whether that same weight and focus is given to defining when it is. Because I know that in some instances, yes, a separate charge may be entered, but does that really encompass all of the circumstances that could come with, if we're treating this as less than criminal, as just a civil or administrative non-compliance? Where is that overtly in the language as well, and is that well understood?
You're talking about someone violates the terms of their probation because they didn't comply with the sex offender
So
registration?
not
Or
necessarily
if they're
while
charged
actively.
with, if they're charged with criminal offense of failing to comply with the sex offender registration, that would be a new offense. Which is in statute, there is statutory language that would be.
Harry, 3 years?
It's misdemeanor.
Misdemeanor.
Yeah.
So if in the review,
Registration, it's failure to follow the registry requirement.
if in the review of an offense or an individual, a defendant's history, it becomes apparent in the review of the case or by the judge that there is a repeated history of non-compliance with registry, registry requirements that maybe didn't rise to the level of a conviction, or were dismissed, but nonetheless are important for demonstrating a pattern of criminal behavior sustained over time. Where would that fit
It would
in?
not be covered under, if it didn't result in a probation violation or a new criminal conviction. That would not be covered the way currently arise. So if a judge, like just the way you described it, identified that pattern that for whatever reason didn't lead to a violation, then we wouldn't currently have that covered.
And I ask partially because I know that, when we discuss, of the items that become discussed, the sex offender advisory board, one of them is the frequency with which individuals who have a criminal history of registerable offenses in their home state or jurisdiction relocate to Maryland temporarily or permanently, partially because the requirements for compliance under our system are so much less than they are in their home state. And if in that, transition, sometimes issues of compliance can become cloudy. This is, I think a lot of times when we take a look at our recidivism data, this is, potentially a very large indicator of a repeated pattern and propensity of behavior. And that if the purpose of this language is to provide guidance in determining when and when it should not weigh upon a defendant's criminality, and I apologize if I'm using that term overtly broadly in the presence of experts, I would just want to make sure that it's very good to define when it shouldn't be used and when it is not criminal, but I think that there is a gray area that we're addressing here that is still important and indicative for these calculations.
Would the guidelines speak to that though? I mean, you're asking that, would the guidelines speak to the scenario where a judge or a probation, it didn't result in a violation or it didn't result in a new criminal sanction? Like, I think the guidelines would then be getting into that very gray area of trying to make a distinction, to come up with some language to identify that scenario where it didn't rise to the.
I don't think so, because I'm not sure
Right.
that, I'm not sure that if a person is not in compliance with their reporting instructions, that it would, and the person who is responsible for supervising them, if they didn't believe it rose to the level of judicial intervention, that a judge would know, a judge would not know. So then,
First,
right, so.
for some instances, I'm so sorry, I did not mean to interrupt you, Judge Middleton. Someone may be on the registry, someone may be a registered sex offender.
Okay.
And as was mentioned here, have another offense completely unrelated to their prior sex offenses or pattern of predatory behavior.
Yes.
Shoplifting charge, right? There's a lot of secondary consequences that are present for this population. But in the course of that supervision, you may find out in doing your intake for that supervision, that individual has moved and they have not updated the registry as they are supposed to. That might just come as a violation. Like, are there other non-criminal, are there other ways that could be present that we're not?
But I think that would failing to report that you moved and without notifying the registry is a crime though. That is criminal, which is different from the other thing.
It would be a new conviction.
Right, that is different.
And if that conviction hasn't yet been adjudicated at the time that another crime is being heard, how would that weigh in? They would then be scored as compliant.
It wouldn't.
I cannot say that it has not been adjudicated.
Just
It would
like
be pending.
if there's any other miscellaneous crime they may have committed, it's not gonna
It would
be
be pending.
considered until there's a conviction, it seemed to me.
So essentially, in that scenario, this person could have absconded or be, criminally fugitive from another state for failing to comply with their registry terms and conditions and be pending adjudication here, and we couldn't score it because.
Couldn't score that he was under supervision as a sex offender is the only thing you couldn't score. Because that's not under the current vote from 2019, it's not considered supervision like probation under that particular one point.
And only if he wasn't also on regular probation.
And also, it wasn't, if he may have already, may also,
Right.
right, if he's on probation for the prior
If
offense.
he's on
you're scoring.
probation, it is a subset we're talking about here, because if someone's on probation and the sex offender registration, they will get the 1 point, because the probation status is gonna put them in involvement in the criminal justice system. We're talking about someone who has completed the terms of their sentence.
Successfully complete, or
And then
completed.
still has this.
Typically, it's gonna be someone beyond. So I think where we see it, it'll come up, it's like, it's been 8 years, 9 years, and they do something, and the question is whether or not that was different, whether they should be treated differently because they were on sex offender registration.
So is there no way to word that? So, because I was telling Dr. Sule earlier, kind of to my point is, and I understand, I guess maybe this is irrelevant, but the concern is when you have a person who has been, for all other words, compliant, completed their supervision and are still on the registry, and then 2 years later, after supervision has ended, they then reoffend for a new offense. They're not gonna get that score for, or that point for the criminal involvement. Now, they'll still have a score for whatever their, prior conviction.
Right.
But I just kind of feel like that part is important because I feel like traditionally what I have seen is a lot of defendants do reoffend outside of that window. Not necessarily, they don't typically reoffend while on supervision. It's there during that term of their registration term.
I just ask, is this an issue that's equally touching whether it was subsequent offense was a non-sex offense versus sex offense? In other words, if it was just a traditional subsequent offense of the same sex offense, they're gonna get hit with increased time anyway, the penalties will be worse. So was the vote really about whether they're gonna get more harshly treated for non-sex offense? It comes up
The
later.
impact's across the board.
Yeah,
It would be the same. They're gonna get a
The
subsequent
impact
offender
across the board.
penalty, but there's a question as to whether they should get a little extra more on top of that because of the.
I think, and again, I mean, I certainly, anyone can correct, that was part of it too, but I think the position that we ultimately originally had as a subcommittee was just, they're on a supervision, so Mr. Harvey knows that they are on a supervision that other people are not. And so it is a consideration. Just like with a lot of the stuff we do, it doesn't mean, this all of our discussion with victim injury. I mean, it's a consideration that a judge is gonna do and how they apply it ultimately in that range. But that was really, it wasn't so much what offense they may commit, it's more about the fact that they were having to do at times very intensive type of supervision.
So just to briefly touch upon what Bob said. When you're on probation, you need to ask permission to move. You need to ask permission to leave the state. You need to ask permission to change your job. All the things that Bob were detailing are things that you must ask your probation officer and get permission before you do. None of that applies to the sex offender registry. You're allowed to move, and then you just notify, I'm moving. You're allowed to take a new job. It's not the same level of supervision. There are similarities because of those areas that are covered, but naturally, I mean, that's what you have to monitor for the sex offender registry to have any effect whatsoever. So I don't think it's the same. There's a lot of distinctions in the level of supervision and in the, nature and manner of the supervision itself.
Well, I don't think you can just move anywhere.
Well, okay,
You can't move next to a school. You can't work in
1,000 feet.
daycare.
It seems to me we're getting in the weeds, all right? Like the issue of whether or not we're counting these points is something we've adjudicated, we've talked about. If we want to revisit that, then the subcommittee should bring up a different issue to the table. But what we're talking about now is,
Language,
I think, a matter of clarity and consistency.
language is what we're talking
Right, so that people are applying these rules in the same way, right, in different areas. So that they don't have to call the commission staff and say, should I charge this point for supervision status or not? Clearly, the current policy, and correct me if I'm wrong, is that the message is, no, don't apply the point. And we're just trying to clarify that, right, in the description so that it's applied the same everywhere. I mean, if we want to revisit whether or not we should do that, that's a different question, but the
Well,
language
that's
is.
why it was brought here. I think if the commission improves the language, it's probably not a reason. Go for it. If the commission doesn't feel comfortable with the language and gives a different direction, that's something we can do. So I agree with you on that.
Well, can I just say then, for the public record, I was on the commission sometime around 2019, I'm trying to decipher if I was at the meeting by looking at the minutes. I may have missed the meeting, this is why I'm asking all these questions, so I apologize for that. But I'll also use that as somewhat of an out to say, I take the judge's point that I guess we don't have before us revisiting that policy decision. So I'm comfortable voting on language that is consistent with the prior 2019 decision that I missed, but there you go.
So can I move that we adopt the language as amended by the subcommittee?
Second.
All those in favor? Any opposed? Motion carries.
I think I had that recorded.
Are we moving on to your report?
Yeah. You have a stream of papers in front of me. I am ready to get that report. I have 7 items to report today under the executive director report. Most of them are pretty brief. First, starting, just want to let everyone know that the Sentencing Commission released new versions of the Sentencing Guidelines Manual and the Guidelines Offense Table effective January 1. I'm giving updates since our last commission meeting. The January 1 updates included revisions to the offense table, as I mentioned, instructions for calculating sentencing guidelines for multiple violations involving temporary violations of criminal article 4-204 and 4-306. You all recall that discussion. And a revision of the definition of psychological victim injury. So that was adopted in January. The January 26 guidelines e-news that we distributed provided further details about these updates, as well as a note regarding the Maryland Automated Guideline System, indicating that the list of offenses has been updated or was updated to reflect revisions to the offense table. And there was additionally a note indicating that several information icons on the offense/offender score screen in MAGS were updated to provide further clarification regarding changes adopted in the last year. The second update I wanted to give was with respect to the annual report. On January 31st, the commission released its 2025 annual report. This report summarized the commission's work during 2025, described fiscal year 2025 circuit court sentencing trends in Maryland, and provided a comprehensive examination of judicial compliance with the state's voluntary sentencing guidelines, and finally detailed information provided and all the data that's collected via the sentencing guidelines worksheet. We also had a description of planned activities for the year ahead, which is where we are now, 2026. I hope you all had a chance to review the report, and if you have any questions about the report, you can certainly send them my way. The third item I wanted to update was regarding the deployment of new features in MAGS 13.0. So it's on March 9th, so a little over a month ago, newer features were deployed in MAGS. The March 9 updates included providing an alert message to help ensure accurate entry of date of birth. This was done really to flag if someone accidentally just does a data entry error and produces an offender who would look like they were very young or extremely old. So we have lots of data checks like that in MAGS. That's one that we didn't have there currently, so we added that. It also includes automatically marking Health General 8507 commitments as corrections options, which they are by definition. And finally, based on discussion during the Sentencing Commission's public hearing and business meeting that we had in December, we added a hyperlink to the Sentencing Commission website and to the bottom of the Sentencing Guidelines worksheet and a footer to the footer of the MAGS application itself. This might seem relatively minor, which it is, but you might recall that we did this purposely to add the website URL. That was done to help pro se litigants who may access the sentencing guidelines worksheets in MDEC. That might be the first time they become aware of what the sentencing guidelines are. And so this will help them direct them to our website to learn more information about the guidelines calculation. The fourth update I want to provide is forthcoming July 6, 2026 updates. This is the next round of proposed sentencing guidelines amendments. It was just published in the Maryland Register on May 1st, and so it now goes into a 30-day period for public comment. We're currently in that period, and assuming everything goes well, those amendments will be adopted effective July 6. The first revision, it will clarify that criminal desertion is not a guidelines offense. This is not a new guidelines rule, but rather clarification of an existing rule. We had criminal non-support in there, and we added criminal desertion just to be consistent. We had received a question about that. Additionally, the guidelines offense table will be modified in July to reflect the addition of 3 previously unclassified offenses that this commission subsequently did classify. Additionally, the reclassification of 1 offense from a property to a person offense, and the addition of 2 offenses with a maximum penalty of 1 year or less. We don't typically add them, but if we think they're offenses that are likely to be prosecuted in the circuit courts, or we've already seen them, we'll add them to the offense table to make sure that they can be easily added in MAGs. The 5th update that I want to provide is with respect to our training and educational outreach efforts. In alignment with the deployment of the new features in MAGS 13.0, our training coordinator, Catherine Pedbrook, provided multiple MAGS-related training sessions on March 25th and 27th, and also on April 8th and 10th to highlight these recent sentencing guidelines updates to our justice partners. We saw a couple of our commissioners that participated in those trainings, so hopefully you found some of the information to be useful. We, as always with these training videos, we post them to the commission website, so anyone could go view these trainings on their own time at any time via YouTube that we link on the commission's website. In addition to the training Catherine provided on April 7th, I participated in a judicial seminar regarding structural inequality. This is part of a larger judicial seminar on anti-racism that has been going on for a few years now. And during that seminar, I participated in, I provide a summary of the Sentencing Commission's July 2023 report assessing racial differences in guidelines eligible sentences. And so I was happy to be able to participate in that judicial seminar. The 6th update I wanted to give is to provide an update on the timeline for the prior record study. At our December meeting, I provided an update on this timeline as well, and I noted the estimated timeline provided the year before in December 2024 would need to be adjusted. And that adjustment was necessary because the commission staff had yet to receive the necessary criminal history rap sheet data. It's something that we've been working to get. And I noted that the process to secure the data sharing MOU and to obtain the corresponding data was more complicated than we expected. Accordingly, we were essentially pushed back on the whole project by 1 year. The good news is that we did receive data in January of 2026. The bad news is that the staff identified a pretty significant missing data issue in the information that we received. So our work has still not progressed at all. We're still waiting to receive the updated data file. Hopefully we'll get that relatively soon. We coordinated meetings with staff from public safety, and they are working to resolve the issue. It was a programming error, I think, to say best. But luckily we caught that, and so we were able to do that. So we weren't doing our analysis with a sample that was short of many cases. So hopefully we'll receive that really soon, and we'll provide a more definitive update to the timeline probably at the next meeting in July, depending on when we get the data, to give us an idea of maybe we'll have some time to look at the data by then too, to give us an idea of how much time we might need to go through it. So that's where we stand with respect to the prior record study. The final announcement that I want to share is regarding our staff research assistant, Bella Nozell. She ended her employment with the commission on May 1st. Bella left for a new career in the federal government, and she was a tremendous asset to the commission. She was with us for 2 years, but she made a big impact on us. We really enjoyed having her, and she will definitely be missed. But it means we're open, have another vacancy currently open. This is for our research assistant position. And I think I sent an email, or you should have received an email from the commission describing the position. And we sent that email on April 27th. So we are asking for.
You sent the email when?
April 27th. you know any good candidates, or you think you may know any good candidates, send them my way or send them to our website to go figure out where the application link goes through the University of Maryland's Workday job application portal. We're asking for best consideration to submit your resume by May 22nd. So we have had the position posted for 11 days, 11 days, and we have 80 plus applicants, which is amazing.
You got anybody math?
Yeah, you need to be good with data. I would say yes. Don't usually find those two go hand in hand. They're usually good at math or good at data. So yeah, we're encouraged by, I don't know if it's a sign of the current market. I guess I do know it is a sign of the current market. So well, we have a search committee, which we're a very small unit, as you know. So the search committee is made up of Stacy as the search committee chair and Catherine and Sarah, who's not here with us tonight. So they actually have the big job because they're gonna be the ones weeding through those. I imagine is gonna be 100 plus applicants by the time May 22nd to figure out. But hopefully that means we'll have some really strong candidates for the position. And maybe if fingers crossed things go well, we might have a new staff member to introduce at the July 9 meeting, July 7th, whatever that. So that concludes my report. Happy to answer any questions.
Do you know what agency she went with? I didn't know the federal government was hired.
She,
Yeah.
I do know what it is. She took a position with the National Security Agency.
Yeah, they need,
Now you know enough. You know any more than that.
they need.
That's it. Not allowed to say anything else. I don't know anything, which is because I don't know.
You're listening to your phone right now.
Upcoming meeting.
Yeah, so just wanted to, sorry, gotta use my paper load. We just wanted, does anyone have the agenda to handy to say, we just wanted to confirm the
Upcoming meeting.
upcoming meeting schedule, thank you. So we are planned for Tuesday, July 7th. Thank you. I was close. That'll be a virtual meeting, and then Tuesday, September 15th, virtual, and then Monday, November 30th for an in-person at the Maryland Judicial Center. And that would be the dual meeting as usual, the public comments hearing. We usually have that in December. I know we had an issue with a facility opening here to have a room here. So we did change it to a Monday. It's a Monday. It's also unusual for us. So that's Monday, November 30th. That's it.
All right, thank you. Is there any old business? Any old business? Any new business?
Yes, I do have one thing. So I don't know, I guess it's been maybe a month or two. I got a call from Judge Tiffany Anderson, Circuit Court of Prince George's. And she had a question that came up where she had a first-degree murder charge. And that he was convicted of, and there was also a conspiracy to commit that same first-degree murder against the same victim they were convicted of. And she had given a life sentence, but the way the guidelines are set up, it was required to be 2 consecutive life sentences because of the conspiracy and the first-degree murder. And so obviously she raised a concern that she's giving someone a life sentence for first-degree murder, and it's below guidelines. And obviously the staff knew the answer right away. I had given that to her. It was very helpful. But it was also one that I saw, and I said, I thought that was something we should probably consider addressing. There are different situations. For example, if there were a rape and a first-degree murder, you might say, okay, I see those being separate. But it seems like when the conspiracy is the very crime of murder against the same victim, this wasn't 2 different victims, which would be fine under victim stacking. We would say, hey, we put them there. But this is the same victim. That perhaps that's something that if the commission was receptive to, setting to the subcommittee and maybe getting some input on that. It seems like that's probably something that would be appropriate to consider when it's the same victim and the conspiracy is for the same underlying act of violence, that life is life, and that's not below guidelines. Because she was had to submit the why was it below guidelines factors. Well, I gave life, and that's a charge that prosecutors will put in. Again, if it was conspiracy to kill A and you were convicted of killing B, that would make sense. But if the conspiracy was to kill A and you were convicted of killing A, it seems like probably that may be something that we could fix, and it sounds like it's something we have to address by I guess, the changing of the rule, correct?
Yeah, if it's something the commission wanted to consider, we would definitely have to, I mean, the rules are, you know, the reason why the guidelines stack there, right, becomes life to life is because the guidelines rules say if you have more than one category 1 and 2 offense, the guidelines get added together or stack, right? So in this instance, both conspiracy and first degree murder are category 1 offenses, or is conspiracy a 2? Conspiracy is 1 as well. So they, by rule, those guidelines get stacked on top of each other. So in that instance, the guidelines were life plus life to life plus life. And the judge imposed 1 life sentence, which is technically below the guidelines. And that judge didn't like. I was trying to figure out how that life sentence. Well, and I think that's where she was coming from as well. I'm not gonna, I would say that is, you know, it's a fair question. I think it's a very rare occurrence. I don't think this is happening. We've never received this question before. One of the things that if it is assigned to the subcommittee for further review, like we'll look at data and see how often this does occur. I think this is a unique scenario where just exist the way Judge Adelia.
Yeah, and it seems like it probably makes sense to have some sort of instruction or comment, like if it's a single victim and the conspiracy was for the same. It's interesting that it hasn't come up more often because it is not uncommon that we see those charges of, you know, of a murder and the conspiracy.
But sometimes the conspiracy merges.
Well, it doesn't technically merge though, it really is 2 separate offenses. So I don't know if it has to be consecutive. That's why it was interesting to me when I heard it. I was like, wow, I never had that issue. And maybe other people just don't fill out the guidelines.
I think for those, if it had merged, then it doesn't get scored under the sentencing guidelines. So the guidelines would have been just like
Just life, right.
right? So that is like the distinction why I made that. It's
Well-
if it merged, like in this instance.
I mean, I certainly have situations where conspiracy to commit a different felony and then a murder,
Right,
and those would be
right.
separate.
Right.
Good question. Wouldn't the judge also be able to explain as to why she deviated from you know, the guidelines just by simply saying that it was the same victim?
Yes.
You know, yeah, okay. So I just want to make sure that opportunity is there as well. Okay.
No, and she did.
Yeah.
She did explain that on the form. It was just more of as a policy thing. It just seemed to maybe make sense as something, if the commission was receptive to that idea, that perhaps we could just take a look at that and see if tweaking that in some way would clarify.
So is there a motion to refer this to the committee?
In the motion.
Thank you.
Alright.
It's been moved and second to refer the issue of considering amending the stacking rule, victim stacking rule. In the scenario where there are 2 convictions for the same victim, felony, murder.
Yes,
The
so
same similar act, conspiracy and the
Conspiracy.
same felony act. All those in favor? Any opposed? Motion carries. Thank you. Any other new business announcements? Their motion to adjourn.
So moved.
Thank you. All right, thank you, everybody.